He's currently on a $5,000 cash bail. Question the bill on this matter.
Yes.
You may proceed, Ms. Dodd.
What's the Commonwealth's position?
Good morning, Your Honor. The Commonwealth is seeking $10,000 cash bail on this newest matter, along with the following conditions: that the defendant remain, or if he posts the bail, that he be placed on a GPS, on house arrest, that he have no access to any computers or smartphones, no use of the internet, including email and social networking sites, among others, no contact with any of the victims in this matter, no work or volunteer work involving children, no unsupervised contact with children under 18, with the exception of his own brother, I believe, and that he check in with probation one time per week in person. The Commonwealth's request, Your Honor, is based on both the strength of the Commonwealth's case as well as the seriousness of the charges. As the court has reviewed in the Commonwealth statement of the case, these charges are in some ways related to the charges for which the defendant has already been arraigned, and in a small but significant way. When the defendant was initially arraigned on these prior charges, those charges were based on an investigation involving a 15-year-old victim who reported to police that she had met someone on the internet who had pretended to be a girl and befriended her, and then that girl had introduced her to another individual who had offered her a modeling job. That individual had then encouraged her to send her naked pictures of herself, which she then complied with, and then that individual threatened to post those pictures online if she did not meet up with and engage in sexual contact with the defendant, his friend, the second person's friend. As a result of those allegations, police began an investigation, and on May 5th of 2011, the defendant's computer was seized. At that time, initial forensics done shortly thereafter revealed that there were upwards of 40 to 50 videos of different apparent young females and some males on the defendant's computer. Most of the videos depicted children in states of nudity as well as in states of sexual conduct. Many of the videos also with them carried chat conversation that you were able to see on the computer. It appears that the defendant had installed on his computer a program by which he was able to simultaneously in real time record whatever was happening on his computer. And so in many of the videos that investigators were able to find, there were indications of what other things the defendant was doing. There are indications of him accessing his own My Yearbook and Facebook profiles, indications of him accessing other My Yearbook and Facebook profiles under other names. Those names also are consistent with names that 17 additional victims, having now been identified by investigators, were able to confirm were names that they were contacted by. Through the course of the additional investigation, police were able to learn that the identity of a number of the victims, the 17 victims who were charged in these indictments, Your Honor, are all from Massachusetts. They range in age. One was as young as 10 years old. The oldest was 18 years old. Some of the children involved, at least one of the victims involved does have developmental disabilities. All of them reported almost the entirely same pattern of contact by the defendant. The defendant would reach out to them after speaking to them on a website called My Yearbook. He would oftentimes pretend to be a 13 or 15-year-old girl. He would then use that contact to put them in touch with other identities of his own.
That's the same mode of operation that's alleged prior.
It is, Your Honor, it is. And all of these victims, without knowing about any of the prior cases or the prior cases details, nor in almost all situations without knowing about each other, reported almost the exact same pattern of conduct. The defendant oftentimes impersonated a modeling agent. He sometimes impersonated a young man. In one case, he impersonated a young man who was ill with cancer. He encouraged these girls, largely girls, to engage in sex acts on webcam with him, claiming that his webcam was broken or not.
Any of the 2012 indictments relate to activity post the arraignment date
Of the 2011 case?
2011.
No, Your Honor, because the defendant's computer was seized in May of 2011, and so all of the allegations that the Commonwealth is charging on the 2012 indictments relate to information that was only learned.
This is all the fruits of the search of the 2000. that followed the 2011 arrest.
In the sense that the information came to investigators that way, yes, but obviously through further investigation identifying these girls and then all of them coming forward and
Well, sure, no, I
being
understand.
interviewed.
I understand that.
Yeah.
But
None of this alleged to have happened.
just so that it's clear, there's no allegation here that since bail was set on the 2011 case that he's engaged in any kind of illicit conduct, in particular of the nature that he was alleged to have done previously.
Right, no allegation here, Judge. But if I may, the facts, although they are quite similar to the allegations of the 2011 case, in the instant case that the Commonwealth has, the most recent indictments, the defendant is alleged to have had hands-on sexual conduct with 2 additional victims, that in many of the cases they were girls who he actually had known previously, who had rebuffed his advances while he had known them in high school when he was a junior and they were freshmen or sophomores, and then he later on found a way to manipulate them by using alternative identities. It's certainly true that the defendant, there's no allegation that the defendant has violated his previous conditions of release or has committed any offense after he was indicted on this matter, on the older matter, I'm sorry. But I would suggest that even though the defendant knew, well, let me back up for a minute. He has been on a GPS, he has been allowed to go to work and to appointments with his lawyer and also to appointments, I believe, at visits at his father's residence. However, I suggest that even though he has known since May of 2011 that the police had his computer and could potentially bring additional charges, I don't think it would be unreasonable to assume that he had no way of knowing that those girls would be identified. Almost none of the girls had screen names that gave their, first and last name in a way that the Commonwealth could identify them easily. It took a number of subpoenas and also additional investigation to be able to determine who the girls were. So I suggest that the fact that the defendant has not, in fact, engaged in any flight or any other similar behavior since he was arraigned on the earlier case, despite the fact that he knew that we had his computer, is not indicative of any sort of predictive behavior that he would not necessarily flee, now facing so many more charges and the overwhelming strength of the evidence before the court. The Commonwealth does have in possession not only his computer, but also an additional computer as well as external devices. The computer forensic investigators have discovered thousands and thousands and thousands of gigabytes of data that are highly inculpatory, Your Honor. In particular, there are, in fact, entire transcripts, for lack of a better word, of the chats between the defendant and many of the victims. There are 8 separate identities that he used on Skype alone that are evident in the chat logs in which he manipulated many of these vulnerable girls into behavior that was undoubtedly criminal and, I would suggest, particularly hurtful and particularly damaging to many of these children. His pattern of behavior, I suggest, and the strength of the Commonwealth's case with respect to the 2012 indictments goes far beyond the allegations for which he was already on release, and the Commonwealth would concede certainly has not violated any of those terms of release to our knowledge. However, I suggest that given the 46 indictments, the fact that he's now facing additional charges of posing which carry a 10-year minimum mandatory sentence if time is imposed, as well as additional charges of sexual assault of children, as well as an additional rape charge of an adult victim, I would suggest is a change in circumstances that would be sufficient to ask for an increased amount of bail for this new matter, to ask for an amount of bail that is above and beyond what he has already posted in the old case, as well as conditions that he, once he posts the bail, that he be on house arrest. This is not somebody, given the breadth of the behavior that we now are aware of, this is not
on the other hand, you're not suggesting to me that during the several months since he was placed on bail with respect to the 2011 arraignment on the 2011 charges took place when?
Your Honor, that occurred in Superior Court on December 8th.
Of 2011?
Yes, and in
when was he charged in district?
July.
So essentially he's been on bail since July of 2011.
Yes.
And were the conditions in the Superior Court case the same as those imposed by the district court judge?
They were not identically. I think I do have...
Well, here's simply my point.
Yes.
We don't have, for example, any evidence that he attempted to contact witnesses or anything of that nature, that he attempted to contact any of the alleged victims or anything of that nature.
Oh, no, Judge. But the Commonwealth's request for bail on this matter is based in, just like in any other case, from a review of just this case, the seriousness of the offenses, the sort of depravity
You
of
do have a history. I mean, the previous charges, there's not as many of them, but they are in themselves very serious and carry the potential of significant periods of incarceration. So we do need to be sensitive to the, notwithstanding the vast number of charges and their seriousness. But the purpose of this hearing today isn't to punish the defendant, it is to ensure that he appear for his next review.
Exactly, Your Honor. But I suggest that the strength of this new case is so far beyond the evidence that we have against the defendant, as you read in the statement of the case, is so overwhelming and is so far beyond the evidence, for example, in any other type of case, that in and of itself, looking at it completely independently, despite the fact that the defendant has, by all accounts, or at least to the Commonwealth's knowledge, abided by the conditions in the prior case, this case is a whole new animal to us. And it does carry with it, I suggest that the evidence is so strong that despite the fact that the defendant was charged with similar offenses which could carry with them similar penalties, the additional charges raise the likelihood of the defendant facing serious committed time.
Likelihood of the first charge is a serious committed time.
Well, Judge, I just say...
Obviously, though, that to the extent likelihoods increase, likelihoods have increased. One needs to weigh that against the risk of flight.
Right.
So, let me hear from you, Judge.
Thank you, Your Honor. First of all, as Your Honor has pointed out, obviously the reason for bail is to ensure whether or not he's going to come here. To answer, first of all, my sister's concern and indication that, well, yes, he did show up all those other times to court, district court and superior court. Yes, he did abide by the GPS and probation and all the conditions actually she's asking for today. This is a totally new situation because he couldn't have known about all these charges. The fact is, he knew before he came here today. It's been all through the press, and of course he was summoned here. So he knew he was coming to face these charges, 46 of them, I believe, and he showed up. So I would suggest to Your Honor...
With respect to the conditions,
yes.
what are the requested conditions that don't presently, let's leave aside the amount here, what are the new conditions that are different from those that have existed for the last several months?
Judge, the Commonwealth is seeking that the defendant be placed on house arrest with no curfew. At this point, he was subject to a curfew. He was permitted to go to work and to other various appointments. We also suggest that there would be, obviously, an additional condition here for no contact with any of these victims, which was not present in the last.
Where's he working?
He's working, the company is right beyond Your Honor. It's in Andover. He worked there beforehand. He is working in a different capacity now there. He's actually looking for more employment to help his family pay, frankly, for counsel. He also helps out. His father is a quadriplegic in a nursing home. He helps out there a bit and he visits his father there. Those are the only things, those as well as being with counsel are the only things he goes out to do. And also I should point out, Your Honor, while my sister is indicating that the nature of these charges is a whole new animal, no, they're not. There's more of them. They're the same charges. Only now they're dating back to years and years ago, some of them apparently having to do with schoolmates. I mean, obviously all this will be fleshed out in discovery. They also hang upon whether or not the initial seizure of the computer was valid, which I believe is going to be an issue in this case. His whole family is in Massachusetts. His father's in a nursing home in Massachusetts. He's not going anywhere.
Judge, there was one additional condition that the Commonwealth is seeking today that was it's not in the prior conditions, which is that the defendant check in with probation one time per week in person.
No problem with that.
So what you're asking me, what difference is as between before and what you ask for presently are an additional $10,000 to give bail and house arrest. And those are the two significant issues that we're discussing already. And the other, I haven't followed all of it, but it seems like in large measure all of the other conditions of release are the same.
Yes, in large measure, in terms of no use of the internet, no use of computers, that
Right, I mean, already his computers have been seized and has been included for using the internet, using email.
his computers were seized that he possessed in May of 2011.
Right,
Yes.
and if he's abiding by the present orders, he's not going online, and he's not using email.
Hopefully, Judge, yes. And I don't have any reason to think that he has.
And I take it in his position at Raytheon,
He helps with wiring in terms of wiring transformers and coils for rockets, that type of thing.
Let's look at the practical aspect of this. Is he able to raise
I mean, not really, Your Honor. I mean, maybe like a little bit, like 1,000 or 2,000. I mean, other than that, you really can't. And you know, right now, obviously, they're hit with the issue of they've retained additional counsel. The father is a paraplegic in a nursing home. That takes a lot of the money. The mother is actually, although she works part-time, she's also got her own medical issues. Things are kind of tight.
living at home now?
He's living at home with his mother and I believe two brothers.
All right. I think this calls for an increase in adjustment because it's a matter of course, but it's not my intent to set bail right now to protect require that he be incarcerated and in trouble. I have to believe that $2,000 can be raised and will be living with his family and the additional reason here as I don't put condition on his parents and so on, so to suggest to me that raising money is difficult. It's the best interest of everyone that he continue to work, so I'm not going to order house arrest. But I would like to know, I mean, I want to, and perhaps the two of you can work it out, I want to be clear that he would be free to work out with probation a list of acceptable reasons for him being able to leave the home, such as to consult with counsel, to visit his father in the nursing home, to go to work, to go to doctor's appointments. It's not clear to me that there ought to be any other reason.
That's right, Judge. And I do believe that he has previously been able to get permission for those specific things that the court has just outlined from probation. I would ask them that if the court is inclined not to place the defendant on house arrest, that the curfew that was imposed in the prior case, which is 6:30 p.m. to 5 o'clock a.m., be imposed on this matter as well.
Well, that, I mean, yes, the answer is it will be imposed, but I'm talking about something somewhat more restricted, that he's not free to move about generally. But I want him to work as long as Raytheon, under the circumstances, is continuing to employ him. He has disabled parents. Under these circumstances, everyone is better served if he's going to work after.
Yes, Ron, the only other thing is that he was looking for further employment as well.
Well, he looks for more employment, he can come back to work. Right now, he will be limited to going to his job at Raytheon. If he is, he can contact probation if he has a particular interview for another employment. Quite frankly, finding additional employment under the circumstances is not going to be an easy thing. Furthermore, I'm not exactly sure how he's going to do it if he can't use the internet and he can't use email. I'm not prepared that he can just drive around responding to all ads in the newspaper. But if he can set up something by telephone, he can call probation and be an understanding and that job interview. It seems like an unlikely event under the circumstances, but so that's where we are. I'm going to set bail in this matter $3,000 in addition to $5,000 pending on the 2011 indictment. We will continue we will have all the conditions, we'll have all the conditions for the 2011 bail, except as to both the 2011 and 2012, we're going to amend those conditions to require a hearing at live with probation once a week, because that's a new condition. And further, that in addition to the curfew, we will restrict the defendant's trips outside the home so that they are limited to work, medical appointments. You have a recommendation? So we're talking about work, medical appointments,
Father's nursing home.
Father's nursing home, to visit his attorney, and any other reasons that the Department of Probation may think is appropriate.
But that those have to be approved by probation.
But those have to be approved by probation. And his trips to work at present are limited to his present employment.
Today? I believe we can do that today very shortly.
Pardon me?
I believe we can do that very shortly today. And also, Your Honor, I was just, there's a filing deadline this coming week in the original case of motions. Obviously, I haven't seen all the discovery, so I would ask if we could amend that.
Should we be consolidating these cases so that he appears with
The underlying case of the session is the people. They would fall down on the plaintiff, consolidate without a
I think that would make sense. The tracking order was just executed last week.
That's fine. So,
To April 25th?
correct.
But Judge,
Sure.
I'm
So
sorry.
that becomes what?
I'll make a pre-trial conference of status for the selection of dates to consolidate both cases together in the 20th rank.
Is that 2 o'clock?
At 2 o'clock in this room.
And sorry, Your Honor. And so additionally in this case, there would also be the condition of no contact with any of the
Oh,
victims.
right.
Director
No
of corrections.
contact.
Thank you.
May that begin, Your Honor? Mr. Hutchinson, please rise on indictment number 2012-357-001. It's ordered by the court that you be confined until you post bail in the amount of $30,000 for charity and $3,000 cash. If bail is posted, you are to be placed on a GPS bracelet, no contact, direct, indirect with the victims in this matter, and weekly reporting to probation. All the conditions on indictment number 2011-1000 are in full force and effect, mid to issue. And if there's a commission of a crime while on bail, can cause a revocation of said bail, April 25th at 2 o'clock for selection of dates.
Thank you. And, Your Honor, just one other thing. My brother is moving to withdraw since I'm coming in.
Good morning, Your Honor. Attorney Vikas Jar, DHAR, on behalf of Mr. Hutchinson in 2011-1000, Judge. I have confidence that this morning's occurrence with both my sister and Attorney Goldberg. I'd be making an oral motion to withdraw with a written filing prior to the end of business on Monday, but that will be served upon the Commonwealth by the end of business today. Thank you, Your Honor.
April 25th.
Thank you.